What are some of the mistakes we see when you're selling on a contract for deed, and how can you avoid them? I'm Jason Wagner, the farm lawyer. We work with family farmers every single day to help them pass on the family farm. Mistake number one, we don't do a title exam. We assume because mom and dad have owned it for so long, or maybe the neighbors owned it for how many generations, that we don't need to spend the time and money to do a title exam. That's a terrible mistake. Just because it's a contract for deed doesn't mean it's not a real estate closing and a real estate transaction. That doesn't mean there might not be easements that we don't know about, or that there's mortgages out there that haven't been satisfied that we think were satisfied. Maybe they are, but we got to clean up the record. If we don't do a title exam, we're not going to know it. We got to do the title exam. It's a simple, not very expensive process, and if you're closing my office, we're absolutely going to do it. Second mistake, not thinking about transfer restrictions. What happens if the person you're selling it to decides that they want to transfer it to somebody else? Are you going to allow that? Who can they transfer it to? Can they transfer it to their descendants, to their spouse, anyone? What are you going to put in there for transfer restriction? These are things that we like to think about when we're setting up a contract for deed. It's not that complicated, but we also have to be careful. We don't want to have unintended consequences. In the state of Minnesota, we've had court cases where an act of death can be considered a transfer. And if we have a transfer restriction, it could potentially be triggering that transfer restriction in the contract for deed, which means it could be canceled. If that's not your intent, make sure that you're thinking it through what exceptions would apply. Mistake number three, you don't charge enough interest. People come in and they say, I want payments to be $25,000, $30,000 a year. We don't want to charge any interest. Well, guess what? You do have to charge some interest. It's called the applicable federal rate. This is the minimum interest rate that the IRS allows you to charge without imputing interest. So we have to know, what is the term, what is the installment period, and how often will interest compound. Then we can calculate the applicable federal rate for your contract for deed. If you don't put this in there, it's just going to make things a mess at tax time. So there are some quick and easy tips for you to avoid in your contract for deed. If you like what you heard, click subscribe, follow me, I'm the farm lawyer, drop a comment below with any questions.